Good afternoon, everyone. My name is Melissa Andre. I'm the Executive Director of the Tax Review Board. Someone just disappeared off the screen. I'm sorry, I'm off. Everyone's here. Okay, sorry, just technical change in my screen. Today we are convening, it's Nancy, that's who just disappeared. Today we are convening, there we go. Today we are convening Tax Review Board. Today's date is September 15th of 2022. It is approximately 2:10 p.m. Please be aware that this is a public hearing and it is being recorded because the meeting is public. Participants and viewers have no expectation of privacy, and by continuing to be in the meeting, you are consenting to being recorded. My chair just I don't know where my chair is. Oh, there she is. All right, my chair is here. I don't know what just happened, but she's back. So Nancy, at this time, I would like to turn to you to call the case.
Okay, thank you, Rich. Good afternoon, everyone. This Tax Review Board hearing for what is today, the 15th of September, 2022. This item before us is for LET Woods docket ending in 8937 and 9304 for a property located at 1848 East Russell Street. This is a continuation of a hearing that began back in April. I believe it was on April 21st. And so it would help all of us to just refresh what was presented, not with a lengthy identification of things, but the highlights or the things that you most want to stress. And if we can, we'd like to start with the petitioner to just get a capsule summary of what was presented at that earlier hearing. I don't know who from your team is going to want to make that presentation. I think Melissa has something to add here.
Yes, I'm sorry. Before we do that, perhaps it would be nice to also refresh the numbers. So if we can just get those one more time for the record, that'd be good.
Good point. So if the city could provide the numbers for the record, please.
Madam Chairman.
Yes.
This is Vito Canuso, the petitioner's attorney. My screen has a covering on it. It says this meeting is being recorded. Can I have that removed?
I'll be there in a second, Mr. Canuso.
Okay.
Yeah, you just have to click on it. That's how I ended up going off the visual for a while. I clicked on that, but I also inadvertently clicked on my picture.
Okay, I didn't want to do anything without permission. I did it. So.
Yes. Okay. Fine. Thank you very much.
Thank you, Madam Chair.
Okay, and so I think really the first thing we need to do is identify who is here, and from the petitioner and then the city, and get those numbers back on the record, and then we'll be back to you for your summary. So please, if the petitioner's representatives would identify themselves for the record.
Yes, my name is Vito Canuso. I'm an attorney and I represent the owners of the property at 1848 Russell Street, Philadelphia. With me is Ellie Woods.
They need to identify themselves, please.
Oh, I'm sorry.
My name is Ellie Woods. I am one of the owners of the property.
Okay, and there's someone else here. I can only see an arm. For
Yes, my name's Paul Desser. I'm here as an expert witness for the plaintiff.
Okay, for the two of you who are not attorneys, do you swear or affirm to tell the truth with everything that comes before the board?
I do.
I do.
Okay, fine, thank you. If we could have the representatives for the city identify themselves.
Yes, this is Michael Rullo, R-U-L-L-O, on behalf of the city of Philadelphia.
And do you have anyone with you who needs to be sworn?
I do. I have Supervisor Rybakowski, and then I don't know if Ms. Fonseca would need to be entered in. She's only going to provide the update as to what the cost of the bills are.
The numbers that we need both of them to identify themselves for the record. Mr. Rybakowski?
Thomas Rybakowski, City of Philadelphia, license and inspection.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you. And missing the name, I don't remember names well.
It's okay. Eileen Fonseca with license and inspections. I'll be reading the numbers for today.
Okay, do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, fine, thank you. If you would then start with reading the numbers into the record, and we may be back to you for something else along the way, if that proves to be an
Sure.
issue.
Sure. I have, first bill is for the demolition bill. I have the bill amount and cost is $84,000, $430.17. Labor cost, $14,653.17. Interest amount, $18,000, $996.75. Total amount, $118,080.09. Sorry.
The third item that you listed, it was demo, labor, and what was the third one?
The interest, I apologize.
Oh, interest, okay. No, it was, I didn't write it down quickly enough. Okay,
Could
um,
you give us the date of that bill?
The date of that bill is November 5th, 2018.
Thank you.
I'm going to object at this point because we never received an itemized bill showing labor costs. And I believe she used a figure of $14,363. We did receive the bill for $84,430.17. But none of the items, and if you see my appeal, was based on the $84,000 plus bill that we received.
we'll note that, but I suspect or believe that was identified as part of the numbers in the last hearing back in April, but we'd have to go back and check the record to verify that.
Thank you.
Okay, does the city have any opening comments before we turn to the petitioner for their summary?
I believe there's a second bill, Nancy.
Oh, there's a second bill?
Yes.
Yes,
Oh,
yes,
my
there is.
apologies.
There's an asbestos bill. And for that asbestos bill, the bill amount is $1,621.40. The labor was $281.40. Interest, $332.10. So the entire total amount due is $2,234.90.
I guess since there was a question about the amount being labeled labor, could you explain what that covers that's different than what you call the primary bill, the asbestos bill or the demo bill? What is
That's the physical work that was done to have the
So-
asbestos removed.
What they gave you.
Unfortunately, that's
And
not,
that date that I have is, I apologize, October 27th, 2018.
Can I ask a question to the city? I am like my colleague. On the first bill, you said 84,000 for the demolition and 16,000 for the labor.
No, it was 14,000 for the
If-
labor.
If I believe that I can,
100,
Yeah,
Um,
please.
Mike,
I believe that I can provide some clarification here. So the bills that the city had entered into the record are exhibits L and M in the city's exhibit packet. And the city is going to, I think that those are the bills that Mr. Canuso had referenced in the petition as well. I believe that those were the ones that were introduced into the record at the first hearing. So the city is going to, work off of the premise, as Mr. Canuso had said, that we're going to be using those bills.
At the last hearing, and I'm only saying this because I just think I think she read them into the record incorrectly. I have that at the last listing, the principal was $69,779. The interest at the time was $17,308.50, and there was an administrative cost of $14,653.17. And the total was $101,738.32. That's more in line with the bill as provided by Mr. Canuso. So
That
I
is-
think she may have included the admin charge and the principal, said the principal and then said the admin charge again. If that makes sense.
I won't say that Ms. Fonseca is wrong, because she is one of my favorite
I
people at
understand.
LNI. But I think that regardless of what the amount is on Ms. Fonseca's bills, that the city is bound by the bills that were entered into the exhibit and as exhibits L and M and the amounts on them, and the amounts that you've just read, Ms. Andre, are correct, and that is reflected in those exhibits L and M.
I do also want to say, this is Ms. Fonseca's first time in front of the board, so we all make mistakes sometimes.
My
Let us-
apologies. Yes, I'm
It's
trying to
okay.
go back on the record on what Richie had. So at the same
under-
time, so.
It's okay. We're okay. Mr. Canuso, are you okay with that, with what was just explained?
Well, as one of the members of the panel indicated, she identified $14,000 in labor costs. That was not the labor cost.
Agreed. I thought I just clarified it. That was an admin cost. That was actually part of the principal. And she just read it separately.
Because one of our arguments is we never got or never received a breakdown of what was the cost of labor and materials as to itemization of anything.
Okay, well, now is the opportunity, I guess, now that that's been cleared up. If we can all agree that that's been cleared up, now I believe it's a good time for you to start your summary.
Yes, and well, I guess just to clarify, because I don't want there to be any kind of confusion. The city has produced the records that it has, and I understand that one of the challenges that Mr. Canuso has raised is the fact that those exhibits do not have that itemization. And so the records that the city has and the records that the city is standing on those points are the exhibits that are reflected in our exhibit packets. So I think that this was just a miscommunication on that front.
So Melissa, could you also read into the record then the asbestos bill?
Sure. I have that the asbestos bill, the principal was $1,621.40. The interest at the time was $56. $56.70. And the administrative charge was $281.40 for a total of $1,678.10.
Thank you.
Okay.
Let's see. We're going to get just a very brief comment from the city before we turn to the summaries. I wasn't sure if these numbers constituted what you were putting in as the starter on this.
Yes, so we are requesting the full amount and the interest that are reflected on those two bills.
Okay.
I didn't know if you wanted me to do a summary first. It sounded like you wanted to.
I think we agreed earlier that we'd go in the normal order with the petitioner and then the city in terms of your summary. And what we're trying to get now, so that it refreshes everyone's memory about what had happened the last time around, is a capsule summary of the points that were made in our presentations back in April. And so if we could start with the petitioner with the highlights or the things that you want the board to focus on from the testimony that was given back in April. And we hadn't discussed what kind of time frame. Does anyone have a suggestion? 5 minutes, 10 minutes, 15?
Just, I believe just a summary, however long they think that's going to take. Just not.
Okay. I was going to try and put people into a perspective of what the time situation should look like. But let's start with the petitioner. And if you would give us some of the key points on the information that was presented last time around to help refresh our memories and get us focused for going forward today.
Yes, and if I may proceed, Madam Chairperson. This involved a fire at the location of the property, 1848 of Russell Street, which consisted of one-story garages. My client received a phone call from someone who did not identify themselves, but informed her of the fire, and that was the only notification she received, and that was on the afternoon of October 22nd. The fire reports, which are exhibits which were presented and which I resubmitted again today, indicate that the first alarm was at 1:39 p.m. on that date, and the fire was extinguished according to the fire report at 2:29 p.m. that date, less than an hour. The extinguishing the fire, the fire report indicates that they requested a contractor to assist them. And it was Palmer Construction Company that was on the scene during the fire and assisted the firemen in extinguishing the fire. As I indicated, the fire report indicates it's one-story roof building, which consisted of 12 garages. And at the conclusion of the fire report, it indicates that the property had already collapsed. However, pictures are showing that a portion of the garages remained at the conclusion of the firemen's work. The owner arrived at the scene of the fire at approximately 6 p.m. That was testified to. At that time, the property was barricaded, secured, gated. No access was available to the owner. There was no posting, and the property was totally secured, and no public admission was possible. We understand that a letter notice was sent, was prepared that day, dated 10/22. However, there's never been any proof of it ever being mailed or no proof of receipt. My client, the owner, testified that they received no further communication from the city as to this event. What appears from the pictures, which have some limitations that have been presented by the city, the condition of the building indicate that the fire was extinguished. There appeared to be no threat of falling debris because it was only a one-story structure at the beginning. No visible condition that appeared to be eminently dangerous, or that there was a concern for damage to adjoining properties because of the way the property was located on the site. And as I said, it was barricaded, landlocked, fenced, gated. And when the owner returned a few days later, it was completely cleared, never having been provided notice of the need to further demolish, further remove, or further have the property cleared. We now know that the next day, on the 23rd, and that is the first day we see that the property is posted. And there was no posting when my client arrived there, or she has no recollection, and there's no evidence that the city presented that the property was posted as a dangerous condition and in need of action by the owner.
I just need to object real quick, just to preserve this for the record, that these are characterizations of testimony. And I just want to make it clear that these were not items that were established as undisputed facts at the last hearing, especially since there's been characterizations of the evidence the city presented. Just preserving that for the record.
We're right now getting the perspectives of each party, and this is the property owner's perspective. You'll have a chance in a few minutes to provide the city's perspective.
Yep, just wanted to preserve that objection. Thank you.
Okay, please continue.
As I said, the owner was denied access to the property because it was barricaded, secured, and gated. And he never had an opportunity to fully evaluate or investigate and properly inspect the premises at the conclusion of the fireman's work, which, according to their records, was early evening of the 22nd. And so there was never a determination as to what caused the fire. Everything had been removed shortly thereafter. No arson investigation, no insurance inspection, no notification to any party that may be responsible to compensate my client was ever provided. You'll see that the next day there were 3 bids submitted as a result of someone making a determination. And we don't believe that there was a proper presentation to this board of the determination that the condition was eminently dangerous and in need of emergency clearing. The first or the low bidder was the Palmer Company that was the one on the site at the fireman's request on the 22nd. We have no evidence or documentation as to the amount of equipment used, the amount of labor used, the amount of material used, or even the timeline as to when the clearing of the property took place. The only thing we do have, and they've been submitted, Burns Waste Disposal shows there were 4 tickets indicating that there were 4 loads of debris removed from the property, 3 on the 25th of October, 1 on the 26th. And that total weight of the debris was less than 9 tons. And the total cost of that removal was only $781.20. We believe that there's some other contradictions that we have in the asbestos report, which shows that the inspector on behalf of the, and this is part of Exhibit J of the city's report of the city's exhibits, indicate that the inspector was on the site on the 23rd, 25th, 26th, and 29th of October. On the 25th, he reports that they did not get access to the basement. There is no basement here. So there's an inconsistency in that individual's report. Further, he reports that there was removal and that on the 29th, when there's no evidence of any work being done on the 29th, no reports of debris being removed. And then he says that they were clearing part of the demolition process on that date it was in the basement. There is no basement. And you'll see that there was one photo of the city of the clear site on dated 5th of November, which is approximately a week after the 29th, which shows that it's a flat surface as a result of all the removal of everything at that site. So there's a lot of inconsistencies here. The interesting thing is the low bid of $69,777 has never been explained and or itemized and or justified. There's void of details. The amount of labor, equipment, removal costs, and dates of performance, and the amount of labor performing the services has never been provided or in some way explained. And it's interesting, my observation, each of the 3 bids, the last 3 numbers of each bid is either 777 or 999. I don't know if that's a code, a message. It's just intriguing to me that a bid would come in with those kinds of figures at the end. As we presented our expert, that he estimated the cost to remove and totally clear this area would approximate $16,500 with a maximum of $25,000 if the labor that was utilized by the city was done by union workers. And that has never been established, never been determined as to what type of labor or what the force of the labor force that was utilized to do the work. And if you calculate that, the cost estimated by our expert results in the city's price being 340% larger, in excess of the price that the owner could have had the job done had she been given the opportunity. We're taking the position that we never had an opportunity to inspect, never had an opportunity to do the work that in the interim, the determination of the imminent danger did not exist and did not require this emergency action at the behest of the city, resulting in this exorbitant amount of money being spent to remove something that was not in any way reasonable or in any way something that should be the responsibility of my client.
Excuse me, one moment. Could you repeat the amount you said that your expert had estimated? I didn't catch all of what you said there.
$16,500.
Okay, thank you.
And then he said that if the work had been done by union employees or prevailing wage payments, that it would be approximately $25,000.
Okay,
For
Okay,
the convenience of the board, that is on page 5 of the expert report, just for the
oh,
convenience.
okay. Thank you, but I wanted to get what he said and I missed the dollar amount and wanted him to go back to that. I'm sorry I interrupted there. Is there anything else that you wanted to add?
One of the reasons is that, in this building, there was no mechanical systems. There was no water, no gas, no electric, no utilities whatsoever. It was a plain building on a flat surface that had very little need to have extra and excess costs or expenses as resulted in this bill. And as you can see, even the pictures on the 22nd that the city has submitted, there's not, though they are limited as to what they show, they don't show an area that remains in an eminently dangerous condition that threatens anyone, let alone the general public. And like I said, the place was barricaded, gated, and totally secured. And again, my client was never given an opportunity to do what had to be done at that location because of the way the city moved forward without proper notice.
I think we've all gotten that point. Is there anything that the board members want to ask about that hasn't been clarified to their understanding of this?
Yes, I want to ask the city a question.
Well, we're going to be getting a city presentation.
I'll wait till after the city presentation. I'm
Okay.
sorry.
Okay, thank you, board members. I will endeavor not to be repetitive and I will endeavor to be as brief as possible. So so first off, I think we should frame where this property is. This property is in the center of a block surrounded on all sides by other properties, which the pictures indicate, and as Mr. Rybakowski indicated, are occupied and most of which are residential properties. This is not a property that just on the side of a street with properties next door to it. It is a driveway that enters into the center of the city block, and then it is surrounded on all sides by properties. And I think that we also need to frame the context of what has happened with this property over the years. And I would direct, this is a property that the owner has neglected for years, and it has been a burden on the neighbors. And I would direct the board members to very briefly the exhibits we presented, which are Exhibit B from 2016, Exhibit O, Exhibit P from 2020, Exhibit Q from 2021, Exhibit R from 2022, which establish that for years, this property has been neglected. The owner allows abandoned cars, trash, etc. And I think that is important to establish the context of the credibility of whether or not the city could trust that the owner was going to act in a diligent manner. So then, as Mr. Canuso indicated, there was this massive fire at the property. And when the city's expert, Mr. Supervisor Rybakowski, who is does this for years, and as you well know, has gone out to hundreds of properties to assess its danger to the public as he is permitted under Section 110 of the code. He made a determination that the property was imminently dangerous. And I would direct the board to Exhibit C of the city's exhibits. I believe that Exhibit C speaks for itself. It shows that the property is in an active state of collapsing. It is the photos, I don't believe it is credible for someone to look at those photographs and say that it's fine, I can walk away, there's a gate up, nothing I need to do right now. And the second thing is, as part of those exhibits, which are from, excuse me, I just need to correct something. It was an emergency inspector who was on site at the time. But the second item here is that if you look at Exhibit C, those photos are from October 22nd of 2018. And if you go down by October 23rd, there was a very clear notice at the property, an orange notice marking and denoting it as imminently dangerous. So I think as an initial matter, the notion that this property was, the owner went out the first day of the property, took a look and said, yeah, you know what, I've got time here, this is fine, I'll just do this on my own, is pretty extraordinary when you look at the state of this property after that fire occurred. I think the other item that I'd like to note is the appellant's expert was not there at the time of the incident. Based on the determination of the inspector at the time, like I said, they determined that it was imminently dangerous. They followed the procedures for what they do in this circumstance, and they bid out the project on an emergency basis to get someone in there immediately to demolish it. And as Mr. Canuso has conceded, the city received 3 bids. They went to the marketplace, they received 3 bids from the marketplace, and they went with the lowest bid. And so I think that one of the things that we need to remember is not only that the expert wasn't there, but while he has provided analysis of what he believes the market cost of this shouldn't be, the city actually went to the market and got a different cost. And at the end of the day, it's the market sets the cost. It's not theory. And then the next thing I'd like to note is that, excuse me. And finally, you know, I just note to summarize that as the board is well aware, when the city incurs these types of costs, it is the taxpayers who are the initial people who front that. And then the city is entitled to recoup those amounts. In this instance, if the board determines that the city is not entitled to its $70,000, which is undisputed that it's spent here, then that burden falls on including the people who are the neighbors of that property that has been neglected for all of these years. And that's the reason why you know, we're going to contend that we're entitled to the full amount, including the interest here. And I will address some of these items a little bit more once I get to Supervisor Rybakowski. Board Member Boyer, I believe you indicated that you had a question. I'm not sure if that's something you want to direct to Mr. Rybakowski or.
I would direct it to Mr. Rybakowski. Do you guys have any engineer estimates of what a per square footage cost should be? I'm going to be very honest. I have been doing demolition my entire adult life, and I represent the workers that do it now. Do we have, because you know those things are very easily accessible without being much of an expert, but do you guys have a price that you'll say, hold on, this looks out of whack?
I
Or
haven't.
you just go by the bids?
We go by the bid, sir. And in this case, we received 3 bids. We took the lowest bid.
Do
And
you
was
do
this a
anything to
sealed bid or
evaluate whether they're
curbside bid?
bidding on the same?
Hold on, was this a
That-
sealed bid or a curbside bid?
This was an emergency curbside bid, sir.
So all the bidders were right there.
Correct.
And with that, may I go into my rebuttal testimony from Supervisor Rybakowski?
Before we turn to that, does any board member have another question?
I have a question with regard to the asbestos report. Is Mr. Rybakowski going to testify to the accuracy of that report? Or do you
Yes.
have anything? Okay.
I believe that he already did testify to that during the case in chief.
Okay, but I think Mr. Canuso raised some valid points of interest about the accuracy of that report.
Understood. So with your permission, then I will consult Mr. Rybakowski as to the on the rebuttal basis.
Thank you.
And then we can address any of those questions to him as we go along if they're still outstanding. So please go ahead.
Supervisor Rybakowski, just for the purposes of the board, can you explain what your responsibilities are with the Department of Licenses Inspections?
As of June of last year, I am a compliance a supervisor for compliance, construction compliance assigned to contractual services or emergency response. Prior to that, I was a building inspector, also assigned to the same unit since 2014.
So you have substantial experience in assessing properties that are in a state of collapse, correct?
Correct.
If you could provide a ballpark estimate, how many of these properties have you inspected?
Either inspected or was on site for curbside bid or demolition bid, several hundred.
Okay. So as Mr. Canuso pointed out, and then we heard testimony at the last hearing, you had heard the expert's testimony that based on his analysis, the cost of this demolition should have been at a maximum $25,000, correct?
I did, yes.
Okay. And you're aware that an assumption in that expert report is that the process calls for the use of heavy machinery to demolish the property, correct?
In the report that was submitted, there was reference of machinery.
Okay. And in this case, did the department determine that it was appropriate to use heavy machinery as part of the demolition here?
When a property is either connected to an adjoining property that is occupied or landlocked, lots of times they will do a hand demolition. I do know that in this aspect, there was a small piece of machinery on location referred to or commonly referred to as Bobcat.
Okay. And in this instance, did the department end up conducting, as part of the bid, was this done by hand to avoid dangers to the surrounding properties?
Yes, it was done by hand and also machined to clear debris.
Okay. And making these determinations like that, it's the sole focus is on the safety of the surrounding properties, correct?
Yes.
Okay. And the city's process here in doing the curbside bid, did the city go through the standard procedures that it uses in every instance to obtain these market bids?
Yes.
And in this instance, we'd heard testimony, in the documents that there were a total of 3 bids, correct?
Correct.
And the city went with the lowest bid.
Correct.
And if the city was to theoretically conduct its own analysis before accepting that, it would have delayed the demolition of this property, correct?
Yeah. Yes.
So just to be clear, the city went to the marketplace, it had multiple bidders, and these were the bids that they received.
Correct.
And excuse me 1 second. I understand that board member Boyer and I believe it was board member Weiss, or Chairwoman Weiss, had some questions about the asbestos bill. If it's possible, given the odd context of this, I would like Mr. Canuso to ask those questions because it wasn't entirely clear about the issues that he was raising and wished to ask Mr. Rybakowski about that. So it just as an initial matter, I think that we need to get that testimony that he's trying to elicit on the record before I can cross-examine Inspector Supervisor Rybakowski about that.
Just for clarification, you're going to have the petitioner's counsel treat him like a hostile witness, and then you're going to, at that point, do a rebuttal?
Yes, it appears that that was what Mr. Canuso wanted to elicit. So under the circumstances, and then the second thing is just given the difficult posture of this. I think that testimony was put on the record at the last hearing, but because this is an issue that has been raised, I think this process is going to make it clearer.
Okay, understood. Thank you.
So who do we need to have next?
Mr. Canuso, did you want to ask any additional questions of Mr. Ribikowski regarding the asbestos report and the issues you raised? And I think, is he on mute? I can't hear him.
Yeah,
Hold on, I think you're on mute, Mr. Canuso,
It's not showing as muted on the screen, but
but I'm not
did
hearing.
someone pull a cord? Hold
Yeah.
on.
Technology is great.
is the mic plugged in? The only thing I can think of.
Board members, while we resolve this, may I step away just for 30 seconds? My dog has had an accident next to me.
Oh, no.
I'm just gonna ask everybody to just hold tight for a little bit for your accident, Mr. Rulo, and to move the petitioners into the other room. I'm not sure what just happened, but.
So,
it's better that we
so
just-
that means that Michael has time to take care of his dog.
Can you hear me? I just need confirmation that someone can hear me.
I can hear you. It's Nancy.
Perfect. Thank you so much, Nancy.
Mhm.
I don't know what. There you go, Ellie. Ellie? In here. Peter? Here we go. There we go.
Once you get settled, if you would each speak so that we can tell whether we can hear you. We heard Melissa when she tested it before you came in the rooms, but love to know that each of you can be heard effectively.
Testing 1, 2, 3.
That I came through, it came loud and clear to me.
We can hear you.
Yeah,
Okay.
if Mr. Canuso's witness could spell his name, that would be a good test for the court reporter.
Desser. First name Paul, middle initial Allen.
Thank
Or
you very much.
Excuse me?
I said thank you.
You're
And
welcome.
we heard him loud and clear. Mr. Rulo stepped aside to take care of a problem with a dog who was beside him. He has not come back on the screen yet. If we can, maybe give him another minute or so to resolve whatever the problem was.
Well, your dog left.
My dog?
Your dog was on the couch. Where did your dog go?
Oh, yeah, she's behind me on the floor.
Oh, good. At least she didn't.
Okay, I didn't know you could see her there. Because I wasn't looking at me on there. That's what I have one on each side of me now on the
Oh,
floor.
lovely. What
Thank
kind?
you,
The Tibetan Terrier.
thank you,
Wow.
board
It's
members.
like
I
over back.
appreciate the indulgence.
And
Everything has
we
been,
were
everything has
talking
been cleaned up.
dogs. You said you had a problem with your dog. I had one that I didn't even realize was visible on the couch behind me, who's now on the floor. So I have one on each side of me. I hope you got your problem resolved.
I have, everything has been cleaned up. Thank you again.
Okay. Okay, let's see. Now that we've got the petitioners in a room where we, at least a moment ago, were hearing their voices, we were turning to them, and I'm not even, I have to admit, I've lost track of what we were going to be
Mr.
asking.
Canuso was going to raise questions to Mr. Rubikowski about the asbestos report.
Okay, thank you very much. So,
If I may proceed.
yes,
Thank you. Inspector Rabakowski, were you at the site at 1848 Russell Street in
No,
October? Pardon me?
no,
So you made no determination as to the condition that existed there?
no,
And you made a comment about our inspector having never seen, or neither you or counsel for the city made a comment about our inspector never was at the site. So your determinations are based on information you received, just like our expert made a determination based on the information that was provided to him by the city of Philadelphia. Am I correct, sir?
I'm looking at the case record on this property,
and what does that tell you?
that the property had been declared eminently dangerous following a multi-alarm fire at the location.
But the person who made that determination was not you, and you do not know any of the factors or what he made his determination based upon. Am I correct, sir? Is
He made the determination upon inspecting this structure following the fire.
And the emergency notice, the first one dated 10/22/18. Is there any verification that when that was provided to the owner of the property?
There's a photograph of the posting of the fence that was erected at the front of the property on an evening of the fire.
But the only photo is dated the 23rd. Am I correct, sir?
Yes, it's dated the 23rd.
And if the owner arrived at the scene on the 22nd, there's no evidence that that posting was there for the owner to vision and read. Am I correct, sir?
If she was there on the 23rd, on the 22nd, no.
Okay. Now, am I correct that the notice declaring that was prepared, declaring that it was eminently dangerous, provided for a time period during which the owner could repair or demolish the property? Am I correct?
Yes,
And how many days notice is that provide, in that notice, how many days is provided to the owner to make the repairs and or the demolition?
typically 10 if the city is not acting under emergency power.
And what was on this notice to the owner?
This notice is computer generated. Typically, if I remember correctly, this would have had a 10-day window.
And of course, as a result of, when you have no evidence that how this was provided to the owners, am I correct, sir?
I don't
I
know.
just got to object. That's a mischaracterization of the testimony. Mr. Rybakowski testified that there was a notice provided on the fence of the property.
But the notice, wasn't there a final notice generated by the city of Philadelphia, and it is an exhibit that was presented by the city, which is in letter form, addressed to the owners of the property at 4832 Olive Street. Mr. Rybakowski?
That's actually generated by the computer system. That was generated as the demolition was going on.
Okay, and so that would have been generated sometime after the 22nd.
Assuming so, yes.
And that provided for the owner to have an opportunity to either make the repair and or demolish the structure. Am I correct, sir?
According to that, but this was done under emergency pretenses.
But there was never a written notice provided to the owner that there was an emergency declaration. Am I correct, sir?
Actually, the property was posted.
Now, you're referring to the machinery. Was there not machinery on the site at the request of the fire department on the 22nd during the process of the fire department extinguishing the fire?
I do know from photographic evidence that there was a bobcat, or what is commonly known as a bobcat, piece of machinery on location.
Well, did you read the fire report that was submitted by me and I think this, well, it's the city's document as to what the battalion, I believe the battalion chief reported on the about the site?
No,
You never read that?
no, I didn't say it.
And if I tell you that says that at the request of the fire department.
Objection, reading from the document has not been presented to the witness to have testimony. So he's reading from a document that currently is essentially not in evidence at this point.
I believe I presented it to the board last time, and I presented it again this morning. I sent it again to the board for.
Can you just identify what document you're reading
Yes,
from?
it's the Philadelphia Fire Department investigation profile report. And it's dated 10/22/18. And
My point here is that the witness has answered that he does not have a recollection or familiarity with that document right now, and he's being asked questions about that document. It needs to be presented so that the witness, given that answer, can answer the question.
Okay, well, I presented.
Was this in the petitioner's packet of exhibits that were sent around for the first hearing?
Yes.
Which exhibit number is this?
Number one.
So number one. So city, you've had this document for months at this point, and you're arguing that your witness has not had an opportunity to review it, or you haven't reviewed it prior to the hearing?
I'm just arguing that it needs to be placed on the screen since the witness, so that the witness can answer questions about it, since the questions here are about the content of that document.
Okay, so do we have the ability to share that document? To share the screen? I can share my screen if you want me to, Melissa. So it's up there.
This is item number one on that list. Is that correct?
Correct.
So this is the correct document. This is the packet from the petitioner. So we're talking about this document here, correct?
Correct.
Proceed forward. Just guide me as you want me to scroll down in it. Counsel for the petitioner, you can proceed forward with your case. How do you want to present this document for the witness to review?
Unfortunately, I think I'm limited by, the only thing I could ask is that it be presented on the screen and shown to him.
Mm-hmm.
We're all learning new techniques in litigation since COVID.
That's how it appears.
Yeah, that's the actual document that was shared via PDF.
Yes.
It's missing a couple of letters on the left-hand side in its entirety.
I don't think that's essential, Madam Chairperson. The most important item, I think, is on the 5th line from the bottom. Pedro Palmer Demolition Company.
Okay. And it says with heavy machinery.
And they assisted the fire department in extinguishing the fire. Am I correct?
According to this report, yes.
And that they assisted also, that the demolition is then assisted in the investigation. Am I correct? Is that what it says?
Where's that at? I'm sorry.
Well, if you read down the next sentence.
So Mr. Canuso, where are we going with this?
Well, I want to ask Mr. Rabakowski, did the demolition company have that equipment left on the site overnight before the bidding took place, or was it all removed?
I don't know. I do know that there was, in photographic evidence, there was a Bobcat on location the day of the fire, according to the evidence packet. Do I know that they took the entire property down by machine? No. I do know that they have to use, if it's connected to an adjoining occupied property, they have to use hand method. In this case, if you look at this report, it makes reference that the roof had collapsed onto the structure or from the structure, creating a freestanding wall in the rear. It also makes reference that they used a piece of machinery to assist in extinguishing the rest of the fire, in that the roof collapsed, preventing them from accessing and putting the fire out completely. So there's a lot of information in this document.
Mr. Rabakowski, did you look at the pictures of the site before the fire that were exhibits of the city?
Yes.
Am I correct that this building was a freestanding building in the center or basically in the center of this lot that had had at least 8 to 10 feet from any wall of the adjoining properties?
You're saying 8 to 10 feet?
Yes.
No. This was a landlocked property with an access driveway going into the bank of garages that were adjacent to residential properties with their yard running perpendicular to the masonry wall at the rear of this property.
No,
This was a multi-alarm fire in a landlocked area with a series of residential properties that had a fire in the rear, that we were concerned with the masonry wall being, it was freestanding and had no structural support from the roof, and that this could collapse on the adjoining properties in their occupied rear yards.
Mr. Rabakowski, if you read the report that's on the screen again, and I'll refer to the 4th line, the second alarm was in staging area and not placed in service. So it was not, though the second alarm was called, the second alarm did not participate in the extinguishing of this fire. Am I correct, sir?
It's still classified as a multi-alarm fire, sir.
Okay, I think we do have the report that we can read, and some of this is a little repetitive. So is there something new that you want to bring out, Mr.?
Well, am I correct that the building that was on fire had a side yard, rear yard, front yard of at least 8 to 10 feet from the walls that you are referring to that belong to the backyards of the residential units.
Yes, but these are yards on residential property. Nothing stops the occupants of those properties coming out and standing in their rear yard, watching a multi-alarm fire of a property that's been neglected behind them.
But at the extinguishing of, at the conclusion of the extinguishment of the fire, none of the debris could get over those walls, could it?
If it has no lateral support at the roof line, that masonry wall could collapse onto those yards.
If there's there's only a 1-story building, and there's a 8 to 10 feet distance between the building and the rear wall of a yard of the residential units. Am I correct, sir?
I don't know, if you want to stand in a yard with a masonry wall and
Okay.
and have no support, that's on you.
I really think we get the point. I really think we get the point. Thank you.
Can I stop sharing this document at this time?
Pardon me?
Stop sharing the document at this time? Are you done with this exhibit, sir?
Yes, ma'am.
Okay.
Mr. Rabakowski, you referred to that you went to the open market. What was that procedure by which you went to the open market to solicit the bids for the demolition that was determined to be necessary?
So when the department does a curbside bid, we serve notice to the contractors that there is a curbside bid of a following property, whatever that address would be. We send out communication to the contractors. The contractors meet at the location. We accept the bids accordingly.
How many contractors were notified?
I don't know.
And is it correct that you have a limited bid list that you send that notice to?
Yes.
And how many are on that limited bid list?
Depends on qualifications. It depends on the budget year. It depends on how many contractors that are on that list.
Well, I'm asking you pertaining to the date of 10/22/18. That's the date at issue here. Am I correct?
Yes.
How many contractors were on the list? And even more importantly, how many contractors were notified of the need to submit a bid on 10/23/18?
I don't have that in front of me.
And you're the compliance inspector for all emergencies. Am I correct, sir?
No, I'm one of the inspectors and I'm one of the supervisors assigned to this department.
So when you said you went to the marketplace, we can't, from what you just said, we can't determine what the marketplace consisted of. Am I correct, sir?
The department received 3 bids for this demolition. We took the lowest bid.
Were you ever at the site, Mr. Rabakowski?
Well, this seems a little repetitive because I believe you've already asked this question and he answered with no. So are there any new questions that you want to ask on cross at this time? I believe we got the gist of your case, but we don't want to cut you off short. So is there anything else that you'd like to ask at this time?
If I may just consult with my client before I end it. Thank you.
Surely. You can turn, okay, you turn.
Mr. Rabakowski, did you go, or did the department go through any process to validate the validity of any of the 3 bids that were submitted?
We took the lowest bid at the time that the emergency was happening and we awarded it to the lowest bidder.
And that means that it was only based on the numbers that were submitted and there was no validation, no determination that that the bid was anywhere reasonable, necessary, and actually reflective of the cost that the bidder would submit. Am I correct, sir?
I believe it was necessary in that this was an eminently dangerous structure.
If the bid had come in, lowest bid had come in at $1 million, would the city have awarded that bidder this project?
Objection, speculation, calls for speculation.
Well, he's part of the process, Madam Chairperson. He has to make these determinations. It's an emergency. Who else is going to make that determination other than someone who says he's a supervisor in an emergency situation in the city of Philadelphia?
It's calling for something that was not a fact here and is completely speculative.
Sustained.
Please continue. If there are any other questions? If not, we'll turn back to the board to see if the board has any questions.
Is Jose Ramos, the inspector that is reported on the city records as being the inspector in charge of this incident, is he a employee of the city of Philadelphia currently?
Yes,
And is there any reason why he's not here to testify today?
he's actually no longer assigned to this, to emergency services or contractual services unit. He is assigned to another department.
And when you say another department, within L&I?
Yes,
Okay. So his availability to testify today is not based on him not being an employee of the city of Philadelphia or an employee of the Department of L&I. Am I correct, sir?
Objection, relevance. This is calling for why the city is choosing its own witness. I don't understand.
Very good. I have no further questions.
Board members, any questions to raise in this context?
If I may very quickly, in his opening, council raised an issue and said that it suggested, implied that something untoward existed with these asbestos bills and the records there. He then didn't ask any questions, and that statement in the opening, which was not testimony, prompted questions from the board. If he's not going to establish a factual basis, which he didn't do right now, then I think that should be stricken from the record because it raised some kind of serious allegations that were the reason why the board had follow-up questions. And now he hasn't presented any evidence to back up what has prompted those questions via asking testimony, which he just had the opportunity to do.
I'm sorry. I limited my questioning to cross-examination, which was based on the testimony. If we want to go into that procedure, and I want to, I would like to have the opportunity to question him about the environmental report, which was the Exhibit J to the city of Philadelphia. That was not raised in direct examination. I am prepared to proceed with that questioning as to the Bell environmental report, which I believe those documents are jointly or referred to as Exhibit J to your exhibits, Mr.
As board member Ward specifically said before this opportunity for council to examine this witness, said it was to provide that opportunity to raise this questions about that precise issue. It was there was zero ambiguity about what the purpose of this was, and he didn't take that opportunity.
May I
agree? I do agree, and I'm going to take this opportunity now to ask my questions. So, Mr. Rudikowski, you're still here. Okay. Are you familiar with the report from the environmental inspector on the asbestos issue?
somewhat, yes.
Okay. Can you explain what his role was at the site?
So anytime the city performs a demolition on a commercial property, which this bank of garages is considered a commercial property, or when we do a 2 or more demolitions on a residential street of a residential property, we are required to have asbestos monitoring and an asbestos report and monitoring at the time the demolition is occurring. If they do find asbestos, then it is abated by an abatement company. But per regulation of the master demolition program, we have to have the heirs, we refer to them as heirs, but it's the asbestos monitoring company on location.
And am I correct that in this situation, there was no asbestos found?
If there was asbestos found and it needed to be abated, then the contractor would have stopped, called in an abatement company.
I understand that part, but in this situation, that did not occur.
Correct.
Correct. So, it's a difficult question. You've testified you were not on site. In looking at the body of the report, which is very minimal, he refers to a description of the property that is, as Mr. Canuso pointed out, completely inaccurate. So how do we explain or confirm that this report actually refers to this property?
How is the description on it, if you wouldn't mind sharing the screen?
It refers to a basement, I believe. That-
Correct.
I don't know, as far as a basement, as this was a bank of garages with slab on grade, which is concrete slab.
That's in the testimony.
Correct.
So my concern and my question goes to the accuracy of this very limited outline of his day, essentially, that then provides a very minimal description of where he was that does not describe the property as we have been told it existed.
It's actually more than one day. There
Yes,
are
it's multiple days.
days that are covered here. And so you'd have to really look at each of those days to see if there are references to basement.
I'm not sure there are.
There is a reference to it on day 1027. I'm not sure that I have looked at every one of them, but it says workers still clearing basement area.
Thank you.
Just for the purposes of the record, that is Exhibit J, page 6.
Right. I'm
I
sorry.
just wanted
Thank
to
you
I just wanted to clarify where
clarifying
that was
that.
correct.
Thank you. Thank you. It's difficult to be on Zoom and stroll through the documents at the same time. But my concern is that this is an inaccurate description is a very minimal report.
I can understand.
There aren't references to basement in the other days, and I don't know how that distinction comes in there. Just double checking, but I think it is only on that one day that
There's
there's
also-
reference to a basement.
No, there is also reference to the basement on the 25th.
No, the 20.
Oh, okay.
And
I
the
was just starting to look at the
In any
25th.
event, there are references to
Right.
that do not accurately describe this property.
Mhm.
And that gives me pause.
Okay. I do not see it on the 25th.
29th, there is no report for the 27th, and I would contend that you know that the 27th was a Saturday and no work
Okay.
was being done.
Okay, the 29th has the references to demolition, workers still clearing basement area, and then basement area cleared. That's the only one,
Anyway,
that is
that's-
the last day.
Thank you, Nancy. Yeah, so anyway,
No, this
I don't
is-
know how that gets explained
Nothing
from
else.
the city's side, but that was what raised my questions. So,
I can only go with what's matter of fact for this property itself. And the matter of fact is this was a bank of garages, slab on grade. No,
Thank you.
no basement.
okay, thank you. I don't have any further questions.
Well, if I may,
I
questions.
I think we already resolved the fact that the petitioner has had their chance to examine Supervisor Rybakowski. I think I'm entitled to now have my go back to him now that there were questions asked by both the petitioner and the board.
And I think I have a right after the petitioner, after the witnesses asked questions by the board member to follow up on those questions.
So let's walk through the posture appropriately. You had an opportunity to cross-examine this witness and treat him hostile, to which we agreed because of the unorthodox posture right now, you went first, petitioner, and ultimately the city does have an opportunity to redirect his witness after your questions that were asked. Now, at the time that you did ask questions, you did not reference the asbestos issue. The city, the board representative did ask questions about it. So I do think it is appropriate for the city at this point to attempt to redirect his witness to basically rehabilitate any type of testimony that came out. After we hear that, I think the board can make a determination if you would be allowed to then again recross.
Thank you.
So, so city, please go forth with your redirect of the witness. Thank you.
Okay. And I will endeavor to be very brief here. So first, Supervisor Rybakowski, you heard testimony and answered questions about a document from the fire department. Is that correct?
Yes,
Okay, so that's not a record of license and inspections, who is the ones, the entity that requested and supervised this demolition, correct?
correct.
Okay, and after the fire was put out, the fire department was not remaining on site for the rest of the demolition, correct?
Correct.
And regarding the property itself, as part of this demolition, you mentioned that the kind of foundational wall at the back of the property was removed, correct?
The one-story masonry wall was part of the demolition, yes.
So there was the issue raised about the basement on Exhibit J, page 6, which appears in a single reference there. So it's correct that you testified that there is not a basement at this property, but am I correct that as part of this demolition, there were elements of the foundation that were demolished?
The foundation itself would not have been demolished. The masonry walls to grade, even with grade, would be demolished.
Excuse me one moment. This is Nancy again. I looked back through and I did find one other reference to a basement that I need to call to attention in this context. And that was on 1026. There's a reference to building demolished, and then in parentheses, it says still can't reach basement. It may be that they couldn't reach it because it didn't exist. It could be that it had filled in. I mean, but I'm just saying that there was reference in one other instance that we did not identify in that earlier discussion.
There may be, being that these are a bank of garages, there may have been like wells or like a pit. Like if anybody goes to like a oil service center where there's a pit that the repair person goes into.
Objection, this is
to get to the car.
speculation.
Sustained,
may-
you know,
that
we're
may be-
speculating.
It's all
Not necessary.
speculation, including the thing I referenced a moment.
Yeah, so
Correct.
let's move on.
Okay. And I'll be very brief with these last questions. So there was a reference to, we've gone through how there were only 3 bids received for this project, correct?
Correct.
The property was declared imminently dangerous, and in the opinion of the department, had to be removed immediately, correct?
Correct.
And that was because of how close this property was connected to the rear yards of occupied properties that those residents could have been and probably were going into, correct?
It was in close proximity to the residential properties to protect the adjoining properties and the public at large. It was emergency, under emergency petition, it was demolished.
And if the department were to stop when it receives a bid and then ask for an extensive analysis of that bid by conducting itself, that would necessarily substantially delay the demolition of the imminently dangerous property, correct?
Correct.
One brief second. The records, and just to clarify this, there have been references to records from the asbestos report. And just for the clarification, that is, those records are only from the asbestos report where the bill was approximately $2,000, correct?
Correct.
So those are not records of the entity that actually demolished the property.
Correct.
Thank you.
If I may,
Were there any questions from board members to follow up on that before we turn back to the petitioner? Doesn't look like there are. Go right ahead then.
Mr. Inspector Rupkowski, the report of the Bell Environmental LLC dated 10/29/18 references the demolition of the property continues. Am I correct?
I don't have the document in front of me, so if you're telling me that that's the date, I'll have to take you on what you're saying.
Well, have you had an opportunity to review the Burns reports, the reports from Burns Waste Disposal Company for this project?
I saw the packets, but I don't have the document in front of me that you're referencing.
And if I told you that the removal dates and the disposal dates only are on the 25th and 26th of October 2018, would you agree with that?
I have to object
So I
again.
think
This is
we've
a-
heard all of
Then I'm-
this
then I'm
before.
gonna
I don't
ask-
know where we're going with this.
Okay, well,
But the
I'm-
other objection here is that he's asking for answers to documents that the witness has said he doesn't remember. How is he
Well,
able to possibly
then-
confirm those questions without the
Okay.
document being
very
displayed?
good, very good. I'm going to ask that he be shown what has been marked as my exhibit number number 4.
For what purpose? Where are we going with this?
Well, I want to show that the Bell Environmental reports that on the 29th, there was continuing demolition of the property and materials removed, yet the receipts for the removal of the debris only are dated up till the 26th, the Friday before the date that the Bell Environmental shows that the debris was being removed from the site.
All right, well, very quickly, because I'm not sure that we're as concerned about that at the moment.
Which exhibit are we looking at?
4.
Four.
I would ask you to scroll down. It says Burns. There are four. That's first one dated 10/25.
Okay,
Next one dated 10/25.
and what are we looking at or for as we look at this exhibit?
As to whether or not there was any debris removed from the site on the 29th of October 2018.
There,
These are the only 4 documents that were provided to me by the city of Philadelphia, itemizing costs of the demolition.
These
I
were-
just have to object on the basis that I don't understand how this document is showing this point, and then B, this is mischaracterizing the record because Exhibit K2 clearly reflects when the demolition was completed.
Yeah, but where's the document? You gave me 4 documents showing the demolition materials being removed from the site. And they are only dated on the 25th and 26th. Now you have a document that says that the demolition continued on the 29th, but you don't show what happened to the debris that was demolished on the 29th, or did it remain on the site? You do show a picture on the 5th of November where the site is perfectly clean, perfectly flat, no holes, no wells, the slab is completely consistent and there is no basement. So there's all kinds of misleading information being provided by the city of Philadelphia.
My objection is just limited to the fact that it was represented that there was nothing in the record, and I'm just noting that that is inaccurate because of Exhibit K2. That is all I'm doing.
All right, so I think, Mr. Canoso, you're really moving into your closing at this
Thank
point.
you.
It's argument. So maybe that's where we need to head to, Nancy?
I think that sounds like where we should be at this point in time, yes.
One other question, if I may. The asbestos report, there was no testing of any of the materials. There was just observation of the materials. Am I correct, Inspector?
That's what the asbestos monitoring is for, to monitor the material to make sure there's no asbestos.
Well, but they make no testing of any of the materials. Was there any testing done?
Not that I'm aware of.
Thank you.
Okay. He answered.
Can you take this exhibit off the screen, please? Thank you. Okay. We're turning to a summary. Is that correct?
Let's get closings.
Would you like the appellant as the appealing party to begin, or would you to do their initial closing statement, or would you like to?
Yes.
Yes. So that would be the petitioner.
Mr. Canuso, you're on.
Thank you. As I said in the brief summary, there was limited capabilities of my client to do what the city determined was required. And there was no proper notice to my client of the need for the work to be done at this site. We also questioned whether or not the condition was eminently dangerous. The look at the picture, you'll see that this building was in the center of a parcel of land that had at least 8 to 10 feet between the side walls and the rear wall and the front wall of each of this building, which consisted of 12 garages, from a wall that enclosed the rear yards of the residential units that surrounded this parcel of land. The determination that property after the fire created a danger to the adjoining residential properties is inconsistent with what anybody observing the condition can conclude. As I said, the amount of the lowest bid is not in any way justified or validated and cannot be consistent with what the actual cost it was to remove the structure that remained, the items that were at the site following the fire, and the assist from Palmer, the low bidder, in extinguishing the fire, the debris that was resulted from the fire, and the amount is exorbitant. The administrative costs, which the city contends was $14,000, has never been explained, never been itemized, never been presented in a fashion that the board can conclude that it was a necessary expense and or obligation of the owner, and yet they're seeking over $14,000 as administrative expenses. It's just an item on an invoice or a bill without any explanation, justification, or itemization. The inconsistencies with the Bell Environmental causes me to have to speculate that the city fabricated the extent of this whole process, including the determination that it was eminently dangerous, not notifying the owner was notified by phone of the original fire, but no further notice to the owner that in that fashion, though they moved almost immediately to remove the structure and the debris that was remaining following the fire without giving my client an opportunity to in any way inspect, complete the removal or demolition or repairs to the property. As you know, they present, and I think they're prejudicial and pictures to try to cause a conclusion that's not relevant in this situation of the condition of the property in 2016, and then pictures of the property in 2020 after the fire. We're only talking about the situation that existed as of the 22nd of October, 2018. There's been no reports, though they present pictures from 2016. There's been no evidence that the city issued any violations on this property that would cause you to conclude that caused or in any way created the fire or created the eminently dangerous situation that they concluded without any backup, any support. And the person who made that evaluation, though he's still a city employee, has not been presented to you to question or for me to have cross-examination of that. And I don't think that's fair for the city to demand that my client now, they're seeking over $100,000 and they have not presented the best evidence in support of their claim. The improprieties in the whole process, I believe, support a finding that my client, and we are willing to pay a reasonable amount. And as our expert said, anywhere between $16,500 and $25,000 based on more experience and more trained employees in conducting the demolition would be an acceptable amount in our owner's responsibility. Thank you for putting up for this whole process that is a little.
Thank you very much for your time and your efforts to explain everything to us.
And I'm sure the board has not had many of these types of cases.
Okay. Let's hear closing comments from the city.
And I will endeavor to be brief. I just want to address 2 points. First, it appeared that there was a suggestion that the city was participating in some sort of fabrication of records. And there is no evidence to support that. And that was in reference, I believe, to certain of the Bell documents. That is a document for someone else. And there's also been no evidence that that was it's completely speculative as to whether or not that was an intentional fabrication or just an error in the document from that person. Second, there was a question raised about the best evidence because the other referenced L&I inspector is not here. That was not raised at the first hearing. If that was a substantial issue that was raised at the first hearing, and then the board would have an opportunity to raise that issue and question it, I would have had the opportunity, possibly, I don't know because it didn't happen, to bring that witness here today. But that issue was not raised, and the city is using a records witness, and it's entirely appropriate to do that. Second, I want to, so first off, in terms of the general closing, a key argument here is this issue of whether there was proper notice. And the allegation on the petitioner does not dispute that the day after the fire, in fact, over that night, there was an orange imminently dangerous sign on the property, and yet they're saying that they had no opportunity to have notice. That essentially amounts to an argument that if an owner comes out to a property the day of the fire, sees a collapsing structure, and then sees a fence up, they're without a sign on it, they're good to go. They don't have to come back the next day. They don't have to do anything immediately to go and check on the property. I think that's an extraordinary claim. And I think that the board can turn to its own experiences to say, if your property burned to the ground and was in a state of collapse, would you show up one day and then not come back for multiple days? Because that's the necessary conclusion if the petitioner is correct and she had no knowledge of notice over the coming days. A second aspect of this, is that there was no imminent danger at the property. As there was this issue raised about how Supervisor Rybakowski and I must admit, eminently qualified expert of the petitioner have neither of them were at the property, and that is absolutely correct. However, L&I's records do reflect that someone did go to the property and make that determination. And the board has seen clear evidence of why that is a determination. I think the board, again, can rely on its understandable experience to say that if you have a property and your backyard and your family perhaps lives in that property, and there is a building in a state of collapse that just had a multi-alarm fire backed up against the backyard that you can go in, your kids can play in, that you would be a little bit hesitant about just leaving that and hoping that the owner acted promptly to demolish that. And that gets us to the next point. The pictures that are in here from 2016 all the way through 2022 are highly relevant because they show that this property was neglected for years, before and after the fire, abandoned vehicles, trash, etc. In that context, why should the city accept that it's credible that this owner would have acted in a diligent manner when we've seen that they weren't coming back out to a collapsing property, and we have records that they were neglecting the property for years? Finally, I'm going to turn to this issue of the size of the bill. At the end of the day, kind of in a capitalist society, it's the marketplace that sets the amount. And this was not just one bid that came in here, it was multiple bids that came in on an emergency basis, and you heard testimony that they ultimately were going to have to do it by hand. And the fire department, while there was a backhoe or a bobcat or I don't know, construction, whatever that device is, on site that day, that's in the fire department's report. And the fire department was not there afterwards. And I think that there's an important public policy implication to whether or not this bill should be entitled to being lowered. If we are now setting a precedent that if a bid comes in from a market process and the city essentially has to go and conduct its own labor analysis, its own extensive analysis, which in this case is an expert report, to see if it thinks that that bid is appropriate. These are imminently dangerous situations. That would create a substantial delay and give owners an opportunity to create some sort of procedural mechanism to then cut out this process. The city has to do this on an emergency basis, and they do that based off of what the market says. So I think there's an important public policy issue that arises there. And then finally, at the end of the day, the board is not sitting in equity. It is here to enforce the written laws, and it is not a body of equity that can adjust those to create an equitable outcome. In this instance, the law is clear. Sections 110 and A500 of the code make it clear that when the city is permitted to do this on an emergency basis, it's permitted to do this bidding process on this, and when it gets that bill, it bills it back to the owner. And if the board is lowering this bill here, it means that as part of them, the neighbors around this property who dealt with this neglectful property for years, who had this massive fire in their backyard, are the ones who are going to bear the cost of whatever this bill is reduced by. So in this instance, we're maintaining that we should be entitled to the full amount, including the interest. Thank you.
Okay, thank you. Board, are you ready to step back and see if we can reach a decision here?
I think we are.
I'm gonna put the board back. If everyone just stay put, we should be back shortly. Thank you everyone for your patience. It's been a long hearing.
It's only the administrator. Oh, here we go.
It was a lively debate, everyone. Okay.
Okay,
Paula, I believe you'll be announcing the decision, correct?
we have everybody back. Okay, thank you. The tax review board is back in session. Thank you all for your patience as we deliberated and also for your thorough presentations today. We appreciate that. We have two bills that we're acting on today. The first one being the air quality / asbestos abatement bill. It's this decision of the board to grant the petitioner's request to have that bill abated. That there was insufficient evidence to establish that bill as being an accurate and accessible bill. As to the demolition bill, it's the decision of the board that the city did make its case as to the imminent danger involved with this property following the fire, however, did not make its case as to the reasonableness or provide sufficient supportive evidence as to the principal. Therefore, the board's decision is to reduce the principal amount by $20,000, abate 1/2 of the interest. We believe that statutorily, the administrative charge will be adjusted based on the reduction of the principal amount. You'll receive, Mr. Canuso, you're going to receive a letter with this decision from the board within 2 weeks. At that time, both parties have the right to appeal to the Court of Common Pleas should either side so desire. If not, the petitioner will have the opportunity to arrange installments for the remaining balance within 30 days of receiving the adjusted bill. I need concurrence from my fellow board members.
Nancy Cameron, I concur.
Dominique Ward, I concur.
And Paula Weiss, I concur in that decision. So I think that concludes our business, gentlemen.
May we be excused?
Yes, thank you very much for your time, Mr. Canuso.
Yes, thank you all. And unless there's something that comes on the agenda other than for this case, we're ready to adjourn.
We are.
Thank
Thank
you
you,
very
everyone.
much.
Bye, everybody.
For,
Thank you. Take
for
care.
giving me the opportunity to let my dog resolve that issue. I appreciate it.
We're all dog lovers. It's fine.
And I have one who's, I can't, guess you can't, there, you can see
Oh,
him
yes.
on the couch.
Yeah,
Yeah. We're all dog lovers.
always great when a dog makes an appearance in a Zoom hearing.
Wait, are we all doing dog pictures now? Can I show you my dog?
We're
too?
Of course.
Sure.
Do
Look what I
any-
started.
Do any of you have rescue dogs?
I don't have any dogs left
Ah.
in my house.
Right.
Thank you.
I have
All right.
another meeting to attend. I appreciate it,
All right, bye,
everyone. Thank you very
everybody.
much.
Okay,
Bye.
thank you all.
But I'll show you